Good afternoon. I'm Judge Bernice B of the United States Court of Appeals, and more relevant for this program, Chair of the Dignity Rights Initiative of the American Bar Association Center for Human Rights. We're pleased to present a timely panel entitled The Individual and the State, a conversation on dignity and the law, sponsored by the ABA section of Civil Rights and Social Justice and the Center for Human Rights. This panel is one of many in a series of rapid response webinars. We're actively planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on these programs. During today's program, we encourage you to ask questions of our panelists through the Q&A function, not the chat function. If you do not see the controls, please ensure that your screen is not idle. We will address questions at the end of the panel. We will be sharing a recording of this program to everyone who is registered so that you can share it widely with your networks. And with that, we're thrilled to bring to you today's program entitled The Individual and the State, a conversation on dignity and the law. And I'm going to introduce our speakers, and then I will introduce our director who is joining us on the screen. So on our panel today, we have Professor Erin Daly, Professor of Law, Delaware Law School, and she is the Executive Director of Dignity Rights International. Along with her, we have Professor James R. May, Distinguished Professor of Law and co-founder of the Dignity Rights Project. He's with the Delaware Law School and co-founder of Environmental Rights Institute at the Delaware Law School. Professors Daly and May are co-authors of the first casebook on dignity law, entitled Dignity Law, Global Recognition, Cases and Perspectives, and a companion book that provides an advanced introduction on human dignity and law. So we're pleased to celebrate these newly published works today and learn more about them from the sources themselves. As I said, joining us on the screen, we have Mr. Michael Pates, who is the director of the ABA Center for Human Rights and, of course, of the Dignity Rights Initiative of the Center. So I want to start today by thanking you, Professors Daly and May, for this really instructive presentation. I want to start off, Professor Daly, by asking you why dignity rights and what are dignity rights?
So thank you very much. So first, let me just thank the ABA and especially Ali for organizing this from a technical side. And also I want to thank Michael Pates and Judge Donald for doing all this work really to bring the idea of dignity to American law through their work at the ABA and creating the Dignity Rights Initiative at the ABA Center for Human Rights. It's a great sort of locus for bringing a lot of these ideas together and really seeing how they affect American law. So when we talk about dignity rights, what we're really talking about is two ideas and then what happens at the intersection of them. First, the idea of human dignity, the inherent and equal worth of every person on the planet, of every member of the human family. And then the idea of rights are the rights that flow from the legal recognition of human dignity. So this is an idea that obviously human dignity has been around since humans have been around, but dignity's incorporation into law and laws paying attention to human dignity really started after World War II. And what we're seeing now in the last 70 some years is just a burgeoning all over the world of rights that are associated with or that flow from the recognition of human dignity.
Okay, you mentioned the worth of individuals. So is the perhaps unequal worth of individuals, does that implicate dignity? I mean, with current events and with cases in constitutional law, 1983 actions, qualified immunity, we hear over and over people say the lives of people in marginalized community are not valued the same as the lives of people in more prosperous communities. And they cite to a lack of equality or disparities in that treatment. Does that implicate dignity rights and dignity law?
Yeah, Jim, do you want to speak to that?
Yeah, it sure does. All of those features, Judge Donald, involve dignity law. And I'd also like to thank the Center for Human Rights and Judge Donald and Mike and Ali and everyone involved. And those of you who are watching, thanks so much. It's a fascinating subject, this idea that human dignity matters in law. So not just as a value, not as a norm, but also as a legal principle that can make lives better. And getting to Judge Donald's question, it's a way of incorporating equality in the law. So dignity has these 4 pillars that Erin and I have, at least how we sort of, the taxonomy of dignity in law is that it's universal, it's inherent, it involves worth, and that worth is equal. And so on the universality part of it is that everyone everywhere has dignity. The inherent part of it is that people are born with it. Human beings are born with dignity. It's not bestowed, it's not given, and it can't be taken away. And that dignity signifies the idea that everyone has worth, and that worth is equal from person to person. So getting to notions in American jurisprudence, it doesn't fit exactly, just because our Constitution, unlike so many constitutions these days, our Constitution, it's a bit it's old and ossified, and we have to break it apart to recognize new rights. And it doesn't recognize dignity as a right. And it's sort of, it's fairly singular in that fashion. There are more than 160 nations that have constitutions that guarantee a right to human dignity, but not ours. So what dignity can do in American law, and I'm using American law, like the ABA kind of speak in American law, is to help animate both the claim and the remedy is brought, say, for example, under the Equal Protection Clause, or a Title VI claim under the Civil Rights Act, or environmental justice, or fill in the blank. So it's a way of making the law work better for more people.
So, Professor May, I'll start with you on this one. I introduced the casebook now, and a casebook suggests that there are cases, but for many people, this is not a concept that we are familiar with. Even though you say everyone has it, cases would suggest that courts have dealt with this. Are these cases from international courts, or are these cases in your casebook from some from the U.S.? And in what areas of the law, other than constitutional and equal protection?
Well, first of all, thank you. That's a great segue for a visual aid. It's a real book. It's a real case book, the first of its kind. Yes, and absolutely there are cases. And some of those are from the US, but most of them aren't. Most of them are from domestic or regional or international tribunals from all over the globe that are interpreting what dignity means under law. I mean, not as a concept or a value or an objective, but as a legal right, laws that guarantee a right to human dignity. So there are thousands and thousands of cases from courts all over the globe. And Judge Donald, to answer your question about what specific areas these cases address, it would be almost easier to explain what they don't address. I mean, they address all sorts of socioeconomic and cultural facets and civil and political facets, from education to the environment, to access to justice, to gender rights, to marriage equality, to I could go on and on and on. But it means that it gives judges a mechanism for trying to address claims in all these different situations, and then like domestic courts, but also, like I said, regional tribunals.
Professor Daly, I had an occasion to read recently about a situation somewhere in the Deep South. I've forgotten the state. I think it was Alabama, where people in a particular community had an environmental issue, which as Professor May just referred to, there were issues with sewage and other things running through the community, so that they did not have good quality water, that there were other issues affecting the health of individuals living in that community because of that condition. And so they were questioning whether or not there was a legal relief that could be afforded to them. Does this implicate dignity? I know Professor May said environmental, and it certainly sounds like an environmental claim and worse. But how is dignity implicated there, if it is?
Yeah, I mean, it definitely is. I think going back to what Professor May was saying about sort of the inherence of dignity in the human person, right? It's a quality that's immanent in everybody. And I think our challenge as lawyers is to recognize the inherent and equal worth of every person and to ensure that law recognizes that. And so when we see injustices, whether they're environmental injustices or any other kind, we can think of dignity as sort of a reminder that when people are treated unequally, it's not only a violation of a particular right, it's not only a violation of some section that's written into some code somewhere, but it's a violation of their human dignity. That's how people feel injuries. They don't wake up in the morning and say, my section 22 rights have been violated. They feel that their dignity has been violated. And so dignity is a way for lawyers to talk to clients, to talk to people about what's really at the core of their injury. And it's a way then to turn that back to courts, to judges, to encourage them to recognize that that human dignity and valuing human dignity and protecting it is so important. And that judges do have tools, whether it's written explicitly into a constitution or a statutory provision or something, or not. The recognition of dignity requires judges, we believe, to pay attention to those kinds of injuries. So to look at an environmental justice situation and recognize that what's at stake here is that people are feeling harmed because of the conditions that they're living in, because of the inequality they perceive, because of the racism they perceive, or other matters. So we do think that dignity does have a role to play in all these different areas of the human experience.
Okay, I want to just say to Michael Pates, at any point in time you wish to pipe in, please do so. But I'm going to ask you, if you would, to monitor the Q&A for me also. And if something comes up that's relevant to what they're talking about now, if you would interpose that question sort of as a co-moderator. And one has come up now from for the professors. And the question is, how does what you've just said differ? How does dignity rights differ from the principles set forth in the UDHR?
Well, in a sense, they don't, because what the UDHR does is remind us that every member of the human family is born equal in dignity and rights. So all of this work and the work that we've been doing really does derive from the thousands of cases that have been decided in every jurisdiction around the world. But those cases really derive from principles first articulated at a global level in the United Nations Charter and then in the UDHR. And much international law, as well as constitutional law, as Jim said, flows from those very principles. And what we're seeing in the law is that whereas the UDHR just sort of articulates these standards, every person's born free and equal in dignity and rights, what the cases do is actually animate that. They implement it and they particularize it by saying dignity matters in this context, in this particular way.
Okay. There's another question. Are there specific cases in which a claim based on dignity will afford relief that would otherwise not be available to a claimant? And secondly, in your research, have you found a case where the U.S. Supreme Court has specifically averted to dignity rights or dignity law?
So I'll take a crack at the first one. Erin, you the second one, is that okay? So for the first one, the answer is yes. So this is sort of the counter narrative question. What difference do dignity rights make? I totally get that. That's a great question. And you don't have to trust me. You can get the casebook or its companion, the Advanced Introduction to Human Dignity Under Law, which is thinner. And you'll see that it does. Dignity rights matter. They provide outcomes that would not have been provided otherwise. There are all sorts of examples in the books and blah, blah, blah. And I won't say, well, then buy the book, but I'll just give you a couple. One is, that comes to mind, involves an environmental situation, environmental pollution and contamination in Nigeria, where it involves the Shell Petroleum Company and flaring of natural gas. So to make an extremely long story short, and for those of you who are experts in this, please forgive me, but where you have oil, you have natural gas. And the natural gas is harder to transport than the oil. So if you're in the middle of something, in the middle of a state, a country, it's easier to move the oil around, to extract it from the ground and move it around. And then you have the gas that comes out with it too, and it's harder to move it around. It requires compression and chilling, and anyway, so you flare it off, you just waste it. And 40% of all the natural gas produced on the continent of Africa is flared. It's just wasted in the oil and gas fields of Nigeria. So what does that have to do with what we're talking about? Well, the Constitution of Nigeria guarantees a right to human dignity. So this is where we're going. It doesn't guarantee a right to a clean environment. And there weren't laws in place to protect people from all the pollution and contamination associated with burning natural gas, because the pollution descends, it's tropospheric, and it causes all sorts of health problems. It affects cattle, crops, you get the idea. So finally, a farmer about almost 20 years ago now brought a lawsuit, and he didn't have anywhere else to turn except for the right to human dignity in the Constitution of Nigeria, and he got a court to issue an ordering Shell to stop engaging in these flaring practices. So that's just one example. I mean, there's another side to that story that's not so cheery, but for now that helps to provide an example, I hope, of a situation where a right to dignity provided relief that nothing else would have.
And the Supreme Court case, Professor Daly.
Yeah, and if I could just add also just globally, and then I'll talk about in the US, but globally, there are a number of cases where where courts are choosing to rely on dignity even when they don't have to. So cases about the right to life, say in death penalty context or in other kinds of contexts, they could just rely on the an equal protection clause or a right to liberty clause or something like that, and they choose to rely on the dignity clause. We were studying in class yesterday cases about patenting the human genome, and it's actually hard to understand why there's concern about that without reverting to the concept of human dignity. So that's just one example of where dignity discourse, let's say, really makes a difference. In the US, the court has in over 1,000 cases mentioned dignity, but the vast majority of those cases mention it in the context of state dignity and the dignity of courts and the dignity of other inchoate things, not as many on human dignity. It's doing that more recently. Much of the Eighth Amendment jurisprudence is actually based on the idea the court has said in Trope v. Dulles and then other cases following that the Eighth Amendment is about nothing less than the dignity of man. We've also seen it as a sort of where the court's privacy jurisprudence in abortion cases, same-sex relations cases, and things like that, what it used to treat as privacy, it has in more recent cases, Lawrence v. Texas, so Bergefell, Casey versus Planned Parenthood, referred to dignity instead of privacy. So we're seeing a possible shift on the court towards thinking about things in terms of human dignity, and it allows the court a certain sensibility that privacy or liberty doesn't quite reach. We'll see where that goes in the future.
No, go ahead, Professor May, please.
Yeah. So just to add on to that, there's also a strain of dignity law in the United States and US jurisprudence that has really nothing to do with human beings. Just by way of example, and not to give those who didn't enjoy civil procedure a headache or administrative law a headache, okay? But dignity finds its way in all sorts of manifestations in US law. For example, is like about personal jurisdiction in Pennoyer versus Neff. Yes, if you remember that great case, the court was characterizing personal jurisdiction as an encumbrance on human dignity. But I mean, sorry, not human, sorry. I didn't mean to use the word on dignity, but not of the human beings involved, but of the states, of the state interests in providing a forum to adjudicate matters. And then all sorts of other Supreme Court cases, look at or examine the dignity of states in other contexts, like with the 11th Amendment jurisprudence about sovereign immunity. That's based upon the dignity of the states, or 10th Amendment, and about commandeering state resources. Again, the court's talking about the dignity of the states, and then all sorts of other decisions about the dignity of judges and courtrooms and so on. But more recently, and since the UDHR, going back to the earlier question, there's more and more jurisprudence, even in the United States, as Erin just mentioned, that actually allows dignity to do the work where it should, that is for people.
As we move into a more, I guess, automated and world where artificial intelligence and other things are much more present in our society, and more functions are being performed by those, do you see dignity rights being implemented there? And if so, how? Putting on your futuristic hat.
I think that's a great and really, really difficult question. In part, it's difficult because we'd have to be sort of specific about exactly what kinds of automation. But one of the things that that sort of some of Jim's comments have highlighted is that in our writing and in our work, we've really focused on cases about human dignity. And when we talk about dignity rights, we're really talking about human dignity rights. Mm-hmm. But there's all kinds of questions about what happens sort of at the borders. So there's questions internationally. There's a lot of sort of discussion in environmental circles internationally about the rights of nature and whether nature has rights and whether nature has dignity. There's questions in the US about corporate personhood, for instance, raising questions about what rights corporations have. And I think raising possible questions about at least raising the conversation about dignity. And at the same time, sort of non-human interests or interests that have to do with robotic rights or other ways that humans and artificial intelligence and technology are going to interact. And I think we are going to have very, very interesting questions about how to deal with human dignity and what the boundaries of that are. If we think about all this, as we were saying earlier, as sort of coming from the UDHR's conception of what a human being is, they weren't thinking about IT, right? They weren't thinking about these technological questions. So I think this generation has much more work to do in evolving the concept of dignity rights to adapt to our new realities as they evolve.
Jim, did you have a comment on that?
I don't. I think that was brilliant. Thank you.
Okay. There's a question in the chat, and the question is, what are some of the best lawyering practices to highlight dignity law in briefs and arguments, knowing that most will not be controlling? And that is from a brilliant law student.
I love that question. I think it's a really wonderful question. So I think there's a lot of different ways of doing this. Part of it is that knowing that courts in many countries pay attention to what courts in other countries are doing. And so if you read the dignity cases, and because this is sort of an emerging area of law, these cases are cases of first impression, or at least the courts are treating them that way because they're treating them as dignity cases for the first time, even if they've raised issues that have been, considered before. So one sort of way of doing this is just by being aware of this global, very robust jurisprudence of dignity that's happening all around the world in every country and really in every kind of legal tradition. And so part of it is just bringing that to the attention of judicial decision makers. Mm-hmm. But I think there's something else going on also, which is, well, I guess two things. One has to do with the Dignity in Practice project that we're doing at the American Bar Association's Dignity Rights Initiative, where we're actually publishing papers on the website, the ABA's website, about how dignity is integrated, not just into constitutional or human rights law, but corporate law, employment law, intellectual property, all these other areas of law where practitioners might not sort of think that it has anything to do with dignity, but in fact it does. And the reason it does is that if it has anything to do with human beings, it has to do with human dignity. The last thing I would just say is that I think that there's a way of practicing law that highlights the human element. A lot of times as lawyers, we get very formalistic. We get caught up in formalities and standards of review and modes of interpretation and all these kinds of doctrines and things. And we forget the people whose lives are at stake in this litigation. And I think that lawyers could really highlight human dignity by highlighting the impacts of law, one way or the other, on the human beings involved, and also letting those human beings speak as much as possible, so that the lawyer is representing not a client or, speaking for the client in their own words, but actually in whatever ways, through briefing, through interviewing, through those kinds of things, really making sure that the client's story gets heard, because that's a way to simply just dignify the client as well, while we represent them.
There are really interesting questions coming from the participants, and I'm going to go over a couple of those, and then I'm going to ask Mike to be prepared to go over a couple more. So I'm going to read questions now from the Q&A, and Mike, there's some in the chat, so if you could post those as soon as I do this. So 2 questions that I'm going to combine. Well, I'm going to give you both of these. One question says, what can be done to raise more awareness about dignity law in the US? And then another question asks, what can be done about some of the mundane, just find that, besides money damages, what can claimants recover when there is a violation of dignity rights?
So first, how to make it do more work in American law is, and I don't mean this cavalierly, it's just kind of the arc of what happens with law, is to use it. So what Erin was mentioning earlier as an example is the ABA Practice and Dignity in Practice project that's on the Center for Human Rights, beautiful website, I might add. And it examines the extent to which human dignity, can affect the practices of law, as Erin mentioned. And also, it gets us thinking about professionalism and the practice of law. Many state rules of professional responsibilities incorporate human dignity, this idea of equal worth. And so I'm not speaking metaphorically, by the way. I mean, they actually say that you have to treat people with dignity. So not only is it a component of the UDHR and the United Nations Charter and the twin covenants on civil and political rights and socioeconomic and cultural rights and blah, 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 I could go on. But it's also a part of our rules of professional practice. So, I'm licensed, and if I'm practicing in a jurisdiction that takes dignity seriously in the practice of law, I have to do it with how I treat my clients, how I communicate with them, how I consult with them, and also in judicial practice too, and how I comport myself, in court. So it matters there as well. So those are just some thoughts off the top of my head about it.
And on the issue, and of course, I mean, we should be framing all of this conversation and all of this work that's happening as in the context of the resolution that the ABA adopted last August, affirming that dignity rights are the foundation of a just rule of law, and urging governments, not just in the US, but elsewhere, including the US, to advance and protect dignity rights in all of their legislative, executive, and judicial functions. So this idea that dignity is central, is the foundation to law, is already sort of recognized by the American Bar Association. And a lot of this work that we're all here to do is sort of a product of that. As far as remedies goes, I think that's a really, really interesting question also. I think that there are ways of imagining remedies, of framing requests for remedies for relief in ways that are sort of pegged to human dignity, if you will. So to go back to the environmental justice situation that Judge Donald was referring to earlier, if a judge were to find that there are violations and that relief is warranted, the judge is going to have a hard time figuring just how much cleanup to do, right? How much money damages, how much, or whatever the other kinds of relief are. And one way a judge can think about that is that the amount of cleanup that's necessary, the level of cleanliness of a river or air or soil or whatever, is the amount that is necessary for people to live with dignity. And to sort of figure out using that as a benchmark. And that might sound abstract. It's really no more abstract than liberty or equality or anything else. And again, there are thousands of cases where courts have done essentially that, where they have ordered relief because there's a violation of human dignity and required governments to fix that by assuring that dignity is recognized. Just to give you sort of one example, in a case about the pensions and the level at which the government should allow pensions, the government in Germany had set pensions too low. And the court said, we're not going to tell you, legislature, exactly what the number should be. That's a legislative function, not a judicial function. But we will say that whatever you do, it has to allow people to live with dignity. So courts are using dignity as a benchmark for determining what level of remedy is appropriate.
If I could just add to that as well about the remedy. Erin mentioned there are questions in the chat box about, what do you get out of it, of involving dignity in a case? Well, I mean, we think it contributes to better justice overall, but it improves the chances of being successful. In the cases show that as well through a couple of ways. First is directly, did you know, because I didn't until I took this project on, that 2 states guarantee a right to human dignity in our country. Well, one state and then the Commonwealth of Puerto Rico. So Montana and Puerto Rico in their constitutions have a cause of action that's enforceable and actionable to a right to dignity. And there are all sorts of cases. And the ones from Puerto Rico in particular are just amazing, about incarceration, equal rights, gender equality, education, children's rights, coming from courts in Puerto Rico, deploying that particular provision. So that's one way, is directly. There are also dignitary torts, which can be, enforced, defamation, libel, and the rest of that. So there's the whole strain of tort law. And then there's the extent to which dignity helps inform other claims that you may or may not be interested in, but, like under the due process clause and substantive due process. Much of the court's jurisprudence on substantive due process over the last quarter century, especially through the words and vision of Justice Kennedy, but is about dignity. And again, I'm not using that euphemistically. He says it's about dignity. He's construing and interpreting the Constitution in a way so as to advance human dignity. So those are, again, just some examples of the way that dignity can be used in achieving a claim and doing lawyers' practitioners' work.
Mike, you want to put some of the questions from the chat? Maybe not. Okay, I will. I'll keep going then.
Unmute. There's only one in the chat that I see. The rest, of course, are in the Q&A as appropriate.
Okay. Yes.
One in the chat. Is dignity to be considered an equitable relief in the U.S. as was King's Bench in common law? To the extent you have that bit of research.
And Jim, it seems like you adverted to that a moment ago. So you want to take that one?
Yeah, sure. I mean, I think, right, it's much more like equitable relief than legal relief, or what it leads to, right? I think that's fair. And I don't have anything else. I don't have anything smart to say about
Okay. In the Q&A, there's a question. Couldn't dignity also be used negatively to restrict rights? For example, using principle of, Mike, finish that for me.
So 1 second here.
Sorry.
That's all right.
I've got it.
So
Couldn't dignity also be used negatively to restrict rights? For example, using the principle of dignity to enforce, restrict gender roles or criminalize acts like sex outside of marriage, same-sex relations, etc.
I think the answer to that is I'm not doubting it. It's a great question. It's complicated. It shows you sort of the complexity of dignity under law. So dignity isn't the same thing as morality. The Supreme Court and federal courts have ever since the beginning of the Republic, sort of upheld the state's authority to regulate morality. That's not what dignity is about. Dignity is about, highlighting, spotlighting the equal worth of human beings. And so that's where it gets complicated. Like it comes up in these contexts, like the ones that the questioner put into the question room question box. I forget what it's called, but about like, sex out of marriage or reproductive rights or a whole variety of settings where you have kind of competing interests, as to whose dignity prevails. And that's a way of thinking about it is because we're trained as lawyers, think who wins, who loses, but dignity doesn't do that. Dignity is sort of, it has this magical quality where it doesn't dictate the outcome, but what it does help is to direct the conversation, to direct, as Erin mentioned, dignity discourse. It leads to a better result instead of demonizing, one side or the other, to recognize dignity on both sides and go from there is the idea.
Okay. Erin, did you want to comment?
No, I mean, I think that's sort of to combine that with one of the previous questions about what are cases where dignity has really made a difference. One of the things that I think is really interesting is that in the last, 10, 15 years, there's been a spate of cases, as you all know, about same-sex relations and in particular same-sex marriage all around the globe. And I think every one of them, maybe I'll just say almost every one of them in case there's one that isn't, but I think every one of them refers to dignity. So in finding that that prohibitions on same-sex marriage or same-sex relations violate the Constitution. So these are interesting cases because pretty much all of them could have been decided, as Obergefell could have been decided, on strictly liberty grounds or strictly equal protection grounds. And instead what the courts are doing here is saying, but there's actually something deeper going on. There's the need for the law to recognize that every person needs to live according to their own ideas, to their own judgments, that there's a theme throughout dignity jurisprudence, that it's really about the full development of the personality, the need of every person to sort of define their own life course. That's the language that's used in a lot of the Latin American cases, their own life project for themselves. And so it becomes sort of a broadening of liberty and a broadening of the self to enable a full flourishing of the self. This is not about autonomy, though. I want to make that clear also. It's not about just saying, I can do whatever I want, because we flourish as individuals in society, in community with others. So it's not about sort of a blanket, this is what I'm doing and I don't care about others. It is about living in society, but it's about making sure that each person flourishes in society. And so I think we see those things in a lot of the cases.
And I think we would have to come back and sort of look at the role of the state, as you've said, in this whole equation, which leads me to the question in the Q&A. What does dignity law have to say about the mundane indignities of life? For example, bus stops that put riders in places that endanger their lives and show how little we respect transit users. And the questioner has put a hyperlink to an article in there, but do you want to comment on that question, either of you, Professor May or Professor Daly?
Well, I'll just get the ball rolling. It's a great question, and I don't know exactly, but what the cases and the use of dignity in law inform us is that it can lead to a better outcome than if there hadn't been dignity in law that's recognized. So think of dignity this way in law. One way is through cases, claims, either dignity-based claims expressly or dignity animating other kinds of claims like under the Due Process Clause that Erin just mentioned, or dignity animating what the remedy might be, as Erin mentioned earlier. But also what it does is it informs the law itself. So it's not just the lawsuit, but the underlying laws. So what that means is that, when lawmakers and policymakers are considering how to address that kind of situation, where a bus route goes and safety and so on, that thinking about it through the lens of human dignity, one hopes leads to a better result than if one hadn't thought about it through that lens.
Okay.
I think there's a lot of ways. I mean, again, dignity really goes to the human experience, and human experience is shaped by major events and also by mundane events. And dignity is there everywhere. And I think that's one of the reasons why this panel today is called The Individual and the State, right? Because it's about the scope of individual flourishing and the human experience and how we want to live as human beings, as persons. And yet, because of that, and because we're talking about it in the context of law, it's about the boundaries between that and the state, and what the state has to do to ensure that everybody lives with human dignity, which is another concept that we get a lot more sort of robustly, if you will, outside the US, is affirmative remedies. But also what the state cannot do, and just the way that the state needs to treat a person as a person in large and small ways. One of my favorite cases, if I can just give an example, is from Ecuador. And it's a case where the petitioner was a very short person. And the claim was that when that person went to a government, sort of a post office or one of those places where there's a lot of different windows and they're all sort of at this height, if you're a little person, you're disadvantaged in how you present yourself to the government official, whether it's a teller in a post office or something else, right? And the court said that the government has to ensure that the windows are made so that everybody can approach, no matter what their height is, everybody can approach the government on an even footing from the same position of dignity. And it's just an example of how a court pays attention to dignity in the sense of paying attention to how a person feels, even in something as mundane as how you feel when you walk up to a post office. But that's not mundane, it's important to a person.
Sure. I want to raise a couple of other questions that have come in. One of them is as follows. Would dignity be transnationally worthy? More specifically, in the opinion of our panelists, could a ruling based on dignity against a U.S. company issued in a country where it's protected as a right be enforced in the U.S. for damages caused by its supply chain? Or, for example, this Nigeria case questioned by Professor May, would it be enforceable in the US? Shell would leave Nigeria with all of its assets if it could. So could you respond to that question? And then there are two others that I want to get to.
So Erin, I started the last one, so please do this.
The civil procedure, I'll leave that to you. I mean, I would just say that yes, to the same extent as that situation would arise in any other context, that the dignity fact of it or the dignity law, and it doesn't change that.
Okay, and there's a related question, and Professor May, if you want to comment further on that, let me give you this related question. Are there present day cases in which the Belmont report or human subject claims are referenced?
I'm sorry, I have to look at the chat.
The Belmont, it's in the Q&A, the Belmont report or human subject claims are referenced. Are there present day cases?
I'm sorry, I don't see the question.
Okay.
Erin, do you have it in front of you?
Well, you look at that. I'm gonna give Professor Daly another one and you'll come back to that one. How can we use the concept of human dignity as a peace building principle to assist in conflict management, especially in light of the very polarized views in our current political climate? How can we be trained to help direct that conversation? The conversations that Professor May mentioned, okay, or that James mentioned.
So that's a really great question. So thank you. Just let us pause and thank you for these really fantastic and thought-provoking questions, many of which raising things that we haven't really thought about. So this is wonderful. Certainly, in general, globally speaking, dignity, I think, has a very big role to play in peace building, transitional justice issues, in part because those conflicts tend to be because people have been treated without dignity, or one side, or sometimes both sides, or all sides feel that they've been treated without dignity. And restoring dignity is sort of really the central pillar of much transitional justice work. In a lot of constitutions, and in a lot of countries, dignity's place in the Constitution, dignity's function in the Constitution, and countries' commitments to dignity, whether it's Germany right after the war, South Africa after apartheid, India after independence, et cetera, there's many, many examples of this, where the constitutions sort of hold on to dignity and foreground dignity as a way of remedying the harms and the oppressions of the past. So that's true at a global level. It certainly could be true at a domestic level now, as we see real profound rifts and rifts of identity in this country. And I think there's a lot of different ways. That's probably for another day, sort of the conversations about how we can use dignity as a tool for discourse, as a tool for understanding different perspectives and what appropriate remedies should be for some of the situations.
Okay.
So I have an answer.
Okay. And
Okay.
would you repeat the question, since some of us may have forgotten it?
Oh, okay. I just scrolled away from the question. But it was
Well,
about
just answer it and we'll figure out what the question was.
Okay, sure. Thank you for the question. And this is going to be disappointing because I don't really know. I've got to give it more thought, more study. But the Belmont report concerns biomedical and behavioral research involving human subjects. It has codicils and the Code of Federal Regulations under federal law and otherwise. I'm not an expert in it, okay? So, but it reminds me of two things. First of all, there are international agreements where similar to the Belmont principles, they incorporate human dignity. I was thinking as I was reading the question, thinking about, someone should write a book. Oh, then wait, I have a book right here. Here it is. The Convention for the Protection of Human Rights and Dignity. It's in the title, and dignity of the human being with regard to the application of biology and medicine. This is an international convention. It requires that human beings, both as individuals and the members of the species, be treated with dignity. So that doesn't directly answer the question. Again, I'll give it more thought, but it also reminds me of the second thing, which is the extent to which there's a diaspora of dignity throughout international and regional law. I won't read all the provisions, but if you ever get the book, it begins on page 30. But beginning with the UN Charter and then the UDHR, virtually every UN treaty that ever sees the light of day invokes human dignity, and that's because it's incorporated, it's embedded in the DNA of the United Nations, and it's an integral part of one of the most influential documents that the world has ever known, the Universal Declaration on Human Rights.
Okay, I saw a hand on the screen and I don't know what to do with that, but let's talk right now about, since we're in a pandemic, I was listening to public radio yesterday and there was an interview from, I believe, a minister from one of the African countries talking about the problem right now in the availability of the vaccine, that wealthy countries have purchased and pre-purchased pretty much most of the vaccine, and that poor countries who don't have the resources basically will not have access to it until way down the road. That seems to me to implicate human dignity. And someone asked the question, what can policy advocates do to enhance or increase awareness about dignity and all of the ways that it may manifest?
So I think, some of the things we've been saying in other contexts are sort of applicable here as well. I think that dignity is not the answer to any particular question, not to any complicated question. It may be the answer to some simple questions, but not to these really complex questions of justice and healthcare and transnational obligations and all those kinds of things. But it is a way of first of all, foregrounding the human experience in the discussions. So often you end up in these policy discussions and people are just talking about money, or maybe they're talking about rights, or maybe they're talking about other abstractions. And focusing on human dignity sort of forces us to remember what's at stake, which is the human experience, human lives. And so if we want to develop a policy for whether it's, medical testing, as in the previous question, or just distribution of the vaccine, it seems to me that the best way of starting that conversation is by figuring out what human dignity requires, right? And then developing a policy to advance those dignity-based goals. And it's more just a way of framing the question and of making sure that the people whose lives matter are at the metaphoric table.
So we have now 6 minutes left. I want each of you to do the following. Talk to me a little bit about how you came to this subject of dignity, what brought you here. And then if you would talk a little bit, and thank you, Professor May, for the show and tell about the book. Talk a little bit about why the book, and then tell people how they can get the book. And since we started with Professor Daly, I'm going to start this time with Professor May. What brought you to dignity? And then talk about the book and why you wrote it, and tell people how they can get it.
Well, why that may be out of order, Your Honor, and I can't believe I said that to a sitting circuit court judge, but my story is really, it's an outgrowth of a book I read about 10 years ago or 8 years ago, which...
Okay. Well, if it's out of order, let's start, I believe in order. Let's start with Professor Daly.
Yes, because it's her
Professor
book.
Daly.
So,
Pivot.
so we've been writing for a number of years now about dignity rights, and a lot of this work came out of some work that I had been doing, and it really just came from reading. I was teaching comparative constitutional law and reading constitutional cases from different parts of the world, and started noticing courts that were talking about dignity in a way that just didn't seem familiar from a student of American jurisprudence. And I just got more and more interested in what the courts were doing and why they were saying that. And one of the things that appealed to me so much about these cases was exactly what I sort of just mentioned. They were so human-centered, and they were so much, and it's not always that the dignity claimant wins, but the court is paying attention to the human experience, which seemed to me exactly what law should be doing. And so I just got interested in reading more and more cases and realizing that there was more and more jurisprudence there. And so we just started realizing that courts are actually taking this very, very seriously. And in some countries, like in the US, it's a bit of a new idea. In other countries, if you try to introduce it, they'll say, oh, but we know all about this. We've been talking about dignity for years in our jurisprudence. So it just sort of, the more we looked into it, the more cases there were, and the more they were doing really interesting things in more different parts of the law.
So Judge Donald, so to add on to that from my experience, however, in a nutshell, is that I sat down with a book almost a decade ago that was written by a friend and colleague, and it just changed the kind of the arc of my professional career and how I saw the law. And it was on dignity rights. It was called Dignity Rights, Courts, Constitutions, and the Worth of the Human Person. And so my background is in litigation and environmental law largely, but also constitutional law and what have you. So I was kind of thinking about, as I was reading it, how can it affect outcomes in environmental cases? A lot of the questions that came in through the chat room, the question box, were sort of about that, not about environment, but what good can it do? So I was wondering about that. And what it did is that it was just open, kind of a brand new world, like Wizard of Oz or something, into how dignity, what people care about most, can make a difference in law. And so for me, I started wondering about how that might affect environmental justice and environmental outcomes. And from that, it led to learning more about how dignity is applied in courts, not just about environmental issues, but things that might be analogous. And then also to cases I was working on in the United States where dignity is involved, like in administrative law, everyone's favorite class, but like about procedure due process. Goldberg versus Kelly, the court makes it about dignity. So that's something that can be put to use with dignity. Climate change cases, the claims in the Juliana case, in the original complaint, are dignity based on the back of the Obergefell decision. So it just got me thinking about the majesty and magic of this concept, that it's both the the norm, how we should treat each other. And it's also what the law can do about it. So the way I was thinking about it, not that this is poetic, but it's going to sound ridiculous, but how it hit me is that it's the one area of law that's both the words and the music. It combines the two. And so that led me to thinking more and more about it. And then Erin and I got to talking about it, and I wondered whether there was any, a case book about it, and there isn't one. So, and then I'll stop, but just 10 more seconds or 12 more seconds is that, there wasn't First Amendment jurisprudence. It didn't begin until 100 years ago. There wasn't a field of international law taught in law schools until about 40 years ago, or 50 years ago, environmental law until about 40 years ago, health law until about 20 years ago. And so what I think is that the next kind of generation of law, given it's just how it's ubiquitous, is dignity law.
How can people get the book? I mean, and everyone should have the book, because all of these things they've been asking us about are in the book. So how can people get the book?
It's published by W.S. Hine. It just came out very recently. So you can get it directly from the publisher. It's now available on Amazon. So those are probably, or you can write to us and we can try to secure a copy for you. So, and then the other book,
The books, yes.
is The Advanced Introduction to Human Dignity and Law. It's a much shorter sort of overview of this area of law. It covers a lot of some of the issues we've been talking about. And it's published by Edward Elgar, and I believe that's also available on Amazon.
They are incredible works, eye-opening. It is a field that that we need to look at and see how we help integrate this into these other bodies of law in our practice. And if it is to be advanced, we will do it. Courts depend on you to bring us these new theories, and we can achieve justice if we put our collective hands and minds to the issue. So get the book. Thank you for being here. There may be some non-ABA people on here, and Mike, if you want to tell them how to get to the ABA Center for Human Rights website to look at those resources, it's your time.
Sure thing, Judge. Thank you. It's americanbar.org/human rights. And you'll see all of the center's work, of course, on the website, including the Dignity Rights Initiative that we've been talking about today. A couple of other projects that under the initiative are the Ecocide and Ethnocide project, as well as the Trial Education project, and of course the Dignity in Practice project that Erin and James talked about today. All good stuff.
Thank you. We want to thank the Civil Rights and Social Justice section for hosting this program. If you're on here and you're not a member of the section of Civil Rights and Social Justice, I encourage you to join. That section is referred to as really the conscience of the American Bar Association. And there's no time like the present for us to be involved in these critical issues. So please join that section. If you're not an ABA member, please join. Thank you so very much for being with us. And I believe this concludes this program.